Good day, class. So today we will only have an asynchronous learning where I will be recording the discussion for today's session. Okay, so we will now continue with our discussion on the family code. Particularly, we are now on Article 26. Okay, so let's read first the provision of Article 26. It provides that all marriages solemnized outside the Philippines in accordance with the laws in force in the country where they were solemnized and valid there as such, shall also be valid in this country, except those prohibited under Articles 35, paragraphs 1, 4, 5, and 6, Articles 36, 7, and 8. 36, 37, and 8. Okay? Where a marriage between a Filipino citizen and a foreigner is validly celebrated, and the divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall likewise have the capacity to remarry under the Philippine law, as amended by Executive Order 227. Okay, so let's first tackle Article 26, paragraph 1. Okay, example, if there are two Filipinos, no, or a Filipino or foreigner will get married in Hong Kong in accordance with the laws therein and valid there as such, this paragraph will tell us that it is valid, okay? Except for those marriages provided for in your articles 35, 36, 37, and 38. For Article 35, specific lamang exception, it only pertains to paragraphs 1, 4, 5, and 6. Okay? Example. A and B, both are male, okay? Filipino sila. Let's say 30 and 31 years old respectively. And they went to Germany where same-sex marriage is valid. And they got married in Germany. They then went back to the Philippines a month after the marriage. Question: what is the status of their marriage? Applying Article 26, we have a marriage solemnized in Germany and valid there as such, 'di ba? And the question that we will now be asking is, will it also be valid here in the Philippines? The answer is no. Because if you can still remember in your Article 15 of the new Civil Code, it tells us that legal capacity is binding upon citizens of the Philippines even though living abroad. And also in your Article 1 of the Family Code, na adihay gisulti nga the marriage is a special contract of permanent union between a man and a woman. In this case, both of them are actually men, no? And the family code currently prohibits marriages between same sexes. And even if it is valid or celebrated, in sa Pilipinas, it will not be given effect. Okay? Okay, let's talk about the exceptions. The exceptions in your Article 35, no, paragraph 1, 4, 5, and 6, unsa man na diha, mao ni katong mga marriages that are void from the very beginning. Okay? Nganong void siya from the very beginning? These are those contracted, ang paragraph 1, ingon diha, those contracted by any party below 18 years of age, even with the consent of parents, even with the consent of the parents or guardians. Ang imong paragraph 4, those bigamous or polygamous marriages not failing or not falling under Article 41. Ang imong paragraph 5, ingon those contracted through mistake of one contracting party as to the identity of the other. And the sixth paragraph is those subsequent marriages that are void under Article 53. Okay? So suppose let's talk about katong kumain kag those contracted, so meaning if magpakasal ka abroad and you are below 18 years old, even if valid na dito sa gawas, ikabot na diri, it will not be given effect. Kanang mga bigamous and polygamous marriages, the same is true. And those contracted by mistake of one of the contracting parties, bisag valid na dito sa gawas, ikabot na diri, di po na siya makonsiderar nga valid. For paragraph 6 of your Article 35, katong subsequent marriages that are void under Article 53. What does your Article 53 say? Tanaw ko na natong Article 53, babe. Article 53 says that, wait, I'll check. Either of the former spouses may marry again after complying with the requirements of the immediately preceding article. Otherwise, the subsequent marriage shall be null and void. Example, A and B are married and there was a decree of nullity of that marriage. What you need to do, no, is to register the decree of nullity of marriage in the proper civil registry. And then you have to deliver the presumptive legitim to your legitimate heirs. And if you comply with both acts, you may marry again. But if you do not do that and you enter into a subsequent marriage, that subsequent marriage is void. That is what is meant in your paragraph 6, okay? So suppose this is the kind of your marriage that you celebrated, and in the place where you celebrated it, it is considered valid. Will it also be considered valid here in the Philippines? The answer is no, because of this paragraph 6 of Article 35. Okay? Another exception, no, to the Lex Luce Celebraciones is your Article 36. Unsay naa sa Article 36 mo ni pinakasikat nga ground, no, for nullifying a marriage. Naging diha a marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. So suppose both of them are psychologically incapacitated and they married in America, where their marriage is considered valid. Will it also be considered valid here in the country? The answer is no, it is considered void, okay? Because the condition of the Filipinos shall be governed by their national laws, okay? Balik gyapon ka sa Article 15, kanang iyon diha, laws relating to family rights, etc., etc. So, the condition of the two Filipinos, what was their condition when they got married? They were psychologically incapacitated. They were suffering from psychological incapacity. And if that marriage is void in the Philippines, void na siya bisan pa og asa gi-celebrate because of Article 36. All right? Now, another exception to the Lex Luce Celebraciones is your Article 37. So may naas Article 37, moning mga void marriages because there is incestuous. Okay? Incestuous marriages. So may gitawag na itong incestuous marriages. These are marriages between ascendants and descendants of any degree. So when you say ascendants, no, and descendants, when we say ascendants mo nang pasaka to the direct line. So from your mama or papa to your grandparents to your great grandparents. So regardless of the degree, no, if you marry your ascendants, no, that would be considered void because it is considered incestuous. Descendants, on one hand, paubos na siya. Okay? Mong anak, imong apo, apos tuhod, apos lapalapa. These are your descendants. And if you marry any of your descendants, regardless of the degree, that would be considered incestuous and therefore void from the very beginning. Okay? Another example of, or another instance wherein your marriage is considered incestuous is between brothers and sisters. So this is whether full or half blood, okay? So under Article 37, if you marry abroad, so balik gyapon ka sa Lex Lucia Celebraciones, bisan pag okay didto, nga magminyo ang managsuon, ikamot rin sa Pilipinas, that will be considered void because it is an incestuous marriage. And it is one of the exceptions to Lex Lucia Celebraciones in your first paragraph of Article 26, okay? Article 38. Another exception is your Article 38. It provides that marriage is void from the very beginning by reasons of public policy. What are the marriages that are considered void by reason of public policy? Kanang between collateral blood relatives within the fourth civil degree, kanang step-parents and step-children, between parents-in-law and children-in-law, between the adopting parent and adopted child, between the surviving spouse of the adopting parent and the adopted child, between the surviving spouse of the adopted child and the adopter, between an adopted child and a legitimate child of the adopter, between the adopted children of the same adopter, and between parties where one, with the intention to marry the other, killed the other person's spouse or his or her own spouse. Okay? In some, no, your Article 35, 36, 37, and 38, if these are celebrated abroad in accordance with the law therein and valid there as such, bisan pag valid na abroad, void na siya here in the country because what determines the validity is not the law where it was celebrated, but the Philippine law. Okay? So, but note that only paragraphs 1, 4, 5, and 6 of Article 35 ang considered nga exception to the lex or to the principle of lex luce celebrationes. So paragraphs 2 and 3, no, what governs here is the law of the place. Okay? Let's go now to your second paragraph of Article 26. Okay? Is celebrated and a divorce is thereafter validly obtained abroad by the alien spouse capacitating him or her to remarry, the Filipino spouse shall have the capacity to remarry under the Philippine law. So long time ago, foreigners were allowed to marry Filipino women, either here or elsewhere in the country or in the world. Okay. So if the marriage does not last, what the foreigners would do is that they will just obtain divorce and they would marry again. But sadly, the Filipinos or the Filipinas in particular could not marry, okay, before this paragraph came into life. So this is so because in the Philippines we have no law on absolute divorce. Wa man gyud tay absolute divorce because we did not have divorce. The presumption is that even if nagpa-divorce na nimo ang foreigner, you cannot remarry. Okay? The only way that a marriage is dissolved is through death or declaration of nullity of marriage or annulment. Okay? In the past, even if the Filipina and the foreigner are already divorced under the national law of the foreigner, and even if the said foreigner is already married to another, the Filipina who is back in the Philippines cannot remarry because under Philippine law, mo lagi na, she's still technically married to the foreigner. Good thing lang that years later, no, we now have the so-called recognition of divorces obtained abroad under this paragraph. So here are the rules now when we talk about divorces in the Philippines. Okay, take note of this. So between a Filipino and a Filipina who marry here in the Philippines, there can be no divorce. Di man ina. The same ra gyapon ang rule, okay? Ikaduha is a foreigner and a Filipina who marry in the Philippines but obtain the decree of divorce abroad. They are considered divorced according to Philippine law so long as the divorce decree is recognized in the Philippines. So mag-go through gina siya sa recognition process before the courts. Okay? Third is in order for the Filipino spouse to marry again, the divorce decree must necessarily capacitate him or her to remarry. Fourth, the existence of the divorce decree and the foreign law in divorce or on divorce, in order for it to be given recognition in the Philippines, must be pleaded and proven in accordance to our rules of evidence. All right? And then it is no longer important if the divorce decree was obtained by the foreigner, by the Filipino spouse, or both. Okay? What is important is that a divorce decree was obtained. So grabe ang evolution sa interpretation sa paragraph 2. Before, grabe kaayo ka strict, no? It's only the foreigner who gets to obtain the divorce decree. Pwede ang Filipina. And then it evolved into bisan pang Filipino mo before and then nahimong Amerikana or Amerikano or nahimong foreigner ang usa and then pwede mo obtain ng divorce and then capacitating that naturalized alien or foreigner to remarry. Pwede na. And then it became now the present rule is that mao na ni pwede na in fact nga ang Filipino mismo or ang Filipina ang mo-obtain sa divorce. Okay? So that's what the Supreme Court said in the case of Minoru Takashi and Juliet Morania versus Republic of the Philippines. This was decided on December 5, 2019. Okay? So what happened man di ay in Minoru Takashi? These are the facts, no? On June 24, 2002, the petitioner and Takashi got married in San Juan, Metro Manila. Thereafter, they moved to Japan, where they bore two children, okay? And then 10 years later, the couple got estranged. Petitioner alleged that her husband failed to perform his marital obligations to her and that Takashi refused to give support to their children and worse, started cohabiting with another woman. So, because of her persistent demand for financial support, her husband suggested they secure a divorce so that the Japanese government would give financial assistance to their children and send them to school. Believing it was for the good of their children, the petitioner agreed to divorce her husband. Consequently, they jointly applied for divorce before the office of the mayor of Fukuyama City, Japan. Okay? So in 2012, the office of the mayor of Fukuyama City, Japan, granted their application for divorce. So pag October of that year, niari siyang Manila and iyang gi-file ang recognition of the divorce. Um, the RTC dismissed the petition because it appeared that it was the petitioner herself who secured the divorce decree, which fact is not allowed under the Philippine laws. Okay. And the petitioner appealed to the CA, but the CA affirmed the decision of the RTC. So it reached the Supreme Court, and the issue raised there is that did the Court of Appeals err in affirming the dismissal of the petition for recognition of the foreign divorce decree because it was the petitioner who filed the divorce? So the Supreme Court here lengthily discussed the history of the interpretation of Article 26, Paragraph 2. And it said that while Philippine law does not allow absolute divorce, Article 26 of the Family Code allows a Filipino married to a foreigner national or to a foreign national to contract a subsequent marriage if a divorce decree is validly obtained by the alien spouse abroad. Under the second paragraph of Article 26, the law confers jurisdiction on Philippine courts to extend the effect of foreign divorce decree to a Filipino spouse without undergoing trial to determine the validity of the dissolution of the marriage. And it cited the discussions of the Civil Code Revision Committee. And And then finally, it said no that there is no real and substantive difference between a Filipino who initiated a foreign divorce proceedings and a Filipino who obtained a divorce decree upon the instance of his or her alien spouse. In the eyes of the Philippine and foreign laws, both are considered as Filipinos who have the same rights and obligations in an alien land. The circumstances surrounding them are alike, and were it not for paragraph 2 of Article 26, both are still married to their foreigner spouse who are no longer their wives or husbands. Hence, to make a distinction between them based merely on the superficial difference of whether they initiated the divorce proceedings or not is utterly unfair. Indeed, the treatment gives undue favor to one and unjustly discriminate against the other. Okay? A prohibitive view of paragraph 2 would do no harm than good. If we disallow a Filipino citizen who initiated and obtained a foreign divorce from the coverage of paragraph 2 of Article 26 and to require him or her to first avail of existing mechanisms under family law, any subsequent relationship that he or she would enter in the meantime shall be considered as illicit in the eyes of the Philippine law. First, ningon ng Supreme Court, any child born out of such extramarital affair has to suffer the stigma of being branded as illegitimate. Surely, these are just but a few of the adverse consequences, not only to the parent, but also to the child if we are to hold a restrictive interpretation of the subject provision. Further, the Supreme Court said that this court should not turn a blind eye to the realities of the present time. It is recognized that not all marriages are made in heaven and that imperfect humans, more often than not, create imperfect unions. It is hypocritical to safeguard the quantity of existing marriages and at the same time brush aside the truth that some of them are of rotten quality. Going back, we hold that marriage, being a mutual and shared commitment between two parties, cannot possibly be productive of any good to the society where one is considered released from the marital bond while the other remains bound to it. Indeed, the interpretation of a statute according to its exact and literal import would lead to mischievous results or contravene the clear purpose of the legislature. It should be construed according to its spirit and reason, disregarding as far as necessary the letter of the law. A statute may therefore be extended to cases not within the literal meaning of its terms, so long as they come within its spirit or intent. Finally, niingon ng Supreme Court, true marriage is an inviolable social institution and must be protected by the state. But in cases like these, there is no more institution to protect. as the supposed institution was already legally broken. Marriage, being a mutual and shared commitment between two parties, cannot possibly be productive of any good to the society where one is considered released from the marital bond while the other remains bound to it. Okay? So remember that it is no longer important if the divorce decree was obtained by the foreigner or by the Filipino spouse or both. Okay? Um, what is important is that the foreign law allows divorce and allows the parties to remarry. Okay? So here, ningon ng Supreme Court, records show that divorce report is what the government of Japan issued to the petitioner and her husband when they applied for divorce. There was no divorce judgment to speak of because the divorce proceeding was not coursed through the Japanese courts, but through the office of the mayor. In any event, since the divorce report was issued by the office of the mayor of the Fukuyama city, the same is deemed as fact of an official body in Japan. So, but whatever name it is called, the divorce report is clearly the equivalent of the divorce decree in Japan. Hence, the best evidence of the fact of the divorce obtained by the petitioner and her husband was that divorce report. Okay? So, the prevailing rule now is that the Filipina or the Filipino can obtain a divorce from the foreign country allowing divorce. Okay? It is no longer necessary no nga alien ang mo-obtain sa divorce. Okay? So in your later on in your practice, no, you would be looking at a lot of administrative matters. And when it comes to the recognition of foreign judgment or decree of divorce, no, pursuant to the rules of court on the effect of foreign divorce or final orders, it is the RTC that shall have jurisdiction over it. Okay, regardless of any prayer by the petitioner for a court declaration of his or her capacity to remarry under Article 26, Paragraph 2 of the Family Code. Okay. So under the administrative matter, it will be raffled to the regular trial courts and not to the designated or regular family courts. And the regional trial court shall be guided by the procedure provided in Article or in Rule 108 of the Rules of Court and other provisions of the rules in accordance with Fujiki versus Marinay. Okay. So before the case of Minoru Takashi, no, mao ni ang mga ni-evolve ng mga jurisprudence sa recognition of foreign divorce, the case of Van Dorn versus Romilio, which I've already read, I believe, and the case of here, Pilapil versus Ibay Sumira. I will give you the notes, Ani, para maka-review mo. And then the case of Republic versus Obrisido. Okay. Now we'll just browse through it. And then the case of Republic versus Manalo. And then finally, the case of Katong Minoru Takashi. So remember, no, in Galapon versus Republic, it was reiterated, no, that pursuant to the majority ruling in Manalo, Article 26, Paragraph 2 applies to mixed marriages where the divorce decree is obtained by the foreign spouse, pwede, or jointly by the Filipino and the foreign spouse, or obtained solely by the Filipino spouse. It's allowed, okay? Remember that principles. So, just a touch on the provision of the Muslim Code. In the case of Rohaina Sumagka versus Abdul Ghani Sumagka, the Supreme Court said that the Muslim Code governs Muslim spouses who first wed under the Muslim law rights and decides to wed again under the civil law rights. Thus, a Muslim man can divorce his Muslim wife under the so-called instant divorce or tulak, even if they were also wed in civil rights. Okay? What's my pertinent provision, Anik? The pertinent provision is Article 13 of the Code of Muslim Personal Laws. Niingon diha, the provisions of this title shall apply to marriage and divorce wherein both parties are Muslims or wherein only the male party is a Muslim and marriage is solemnized in accordance with the Muslim law or this code in any parts of the Philippines. Paragraph 2 states that in case of marriage between a Muslim and a non-Muslim, solemnized not in accordance with Muslim law or this code, the Civil Code of the Philippines shall apply. Subject to the provisions of the preceding paragraphs, the essential requisites and legal impediments to marriage, divorce, paternity and filiation, guardianship and custody of minors, support and maintenance, claims for customary dower, betrothal, breach of contract to marry, solemnization and registration of marriage and divorce, rights and obligations between husband and wife, parental authority, and the property relations between husband and wife shall be governed by this code and the other applicable Muslim laws. Okay? Also note that in the case of spouses malaki versus people, the Supreme Court, a party to a civil marriage who converts to Islam and contracts another marriage despite the first marriage subsistence is guilty of bigamy. Likewise guilty is the spouse in a subsequent marriage. Conversion to Islam does not operate to exculpate them from criminal liability. Further, a married Muslim cannot marry another. In exceptional cases, a Muslim man do so if he can deal with them with equal companionship and just treatment as enjoined by Islamic law. Okay? It's also good no, to know some of the rules or laws under the Islam. We'll continue our discussion on Articles 27 to 34 on the next installment of this video. Thank you.